now in session. The Honorable Scott Mayfar, Judge presiding. All persons having business before this court draw near, give attention and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning, everyone, and welcome to the 5th District Court of Appeal. We have two cases on our docket today. With me is Judge Eric Eisenagel, and also Judge Joe Boatwright. Counsel, you've set aside, I guess, 5 minutes for rebuttal, or would you like something different?
No, Your Honor. 5 minutes would be fine. Thank you.
Okay, very good. We'll start whenever you're ready.
Thank you, Your Honor. Good morning, and may it please the Court. Jack Ryder on behalf of Travelers. And Your Honors, I'm going to focus primarily today on the issue of whether or not this verdict is against the manifest weight of the evidence and our remitter argument. And Your Honors, this is a verdict, $16 million verdict, that is clearly contrary to the manifest weight of the evidence and bears no reasonable relationship to the evidence presented, and we believe a new trial is warranted, or at a minimum, a remitter. And here, Your Honors, the trial judge openly expressed her own shock at the outcome here. If we look both throughout the hearing on our post-trial motion and in the order that the trial court entered, the court noted for example, at the record at 2529, that, quote, most death cases don't come back like this. Most quadriplegic cases don't come back with these numbers. And the judge noted in that same record cite that, quote, there seems to be a disconnect about her injuries in the verdict vis-a-vis verdicts that are rendered in the state every day. And here, Your Honors, what we had was a plaintiff who, respectfully, while she did suffer injuries, and we acknowledge that, this wasn't a case where she had broken bones or head injury or paralysis. There was a period of 2 years which she did not treat in any way. She did not have surgery before trial, and it was unknown if she ever did have surgery. She treated with Advil for headaches. She never ceased working, worked full-time, lives on her own, testified that she continues to go boating, hiking, traveled extensively.
Well, counsel, if I can interrupt, just to get the context of this case, your client put on no evidence, correct?
That's correct.
Made no witnesses.
Let me rephrase that.
Let me finish. No witnesses. I mean, you can come back and sit and fill in the blanks for me. No objections at trial of anything, and then waited till after the verdict to file a motion for new trial and remitter at that point, correct?
With one point, Your Honor. There isn't, to suggest that the defendant put on no evidence is a bit of a misnomer because the parties jointly put in the medical records, and the defendant relied upon the medical records as joint exhibits, and the defendant cross-examined witnesses. We did not put on a specific case in chief, but to be clear, the defendant did, and I think there's some very critical points here.
Well, what I hear you saying, though, is you put independently on no independent witnesses or any independent evidence. It's only what was stipulated to.
We did not put in our own experts or our own evidence. We relied on the examination of the plaintiff's witnesses and the joint exhibits, which were presented together, and we rely on those medical records for purposes of arguing that the verdict is against the manifest weight of the evidence and that a remitter was warranted. And I would highlight, Your Honor, and this is something that I believe the trial judge misapprehended, the defendant has no duty to put on evidence. The defendant has no duty in terms of whether it's presenting evidence as competing experts.
That's true, counsel, but the defendant has to abide by the standards of review. And if there's no objections made and there's only evidence the jury had was what the plaintiffs put on and it was cross-examined, of course, I mean, that leaves you with just the fundamental error standard, correct?
No, Your Honor. That is not accurate. This is not about fundamental error. We do have a fundamental error argument, but not as our threshold point. The threshold point is that taking
on the manifest
evidence,
weight, I'm sorry to interrupt, but on the manifest weight of the evidence, you did make a argument along those lines below.
well, we've moved for new trial in the manifest weight.
Right.
In other words, our position, Your Honor, is that a defendant doesn't have to raise an objection or put on evidence or even be at trial. A case could go against a defendant in absentia or a defaulted defendant, and the judge still has a duty.
I guess I'm just not entirely sure. I understand how you are interpreting the trial judge's comments, but I'm not entirely sure that the trial judge analyzed the motion the way that you're interpreting it, right? I mean, why didn't the trial judge just basically say, hey, look, the jury had all of this evidence, you don't like the result, and gee, maybe it would have been different had you offered some alternative evidence that the trial judge could then sort of compare it to, right? But when there's just one story told, gee, the trial judge says, I don't know I can't say that the verdict is against the manifest weight of the evidence. From that point of view, gee, had you offered some alternative evidence, maybe it'd be a different story. Why isn't that what the trial court was saying?
Because what the trial judge did here, Your Honor, is weigh the evidence not against the outcome based upon the injuries suffered, which I believe the trial judge had a duty to do both under Florida law and under the remitted statute, which provides a legislative mandate to examine the evidence compared to the outcome. But what the trial judge did, respectfully, was say that instead of looking at the evidence compared to the outcome, the trial judge extensively focused on defense counsel's performance, talking about it as a, quote, failed strategy, unquote. In fact, she specifically wrote in her order at 2368 that the court is not inclined to excuse remedy mistakes of trial strategy, unquote. And then at the record at 2377, the judge wrote, the court is guided in large part by the fact that little defense was presented and that this jury was given little choice to return the verdict. And at 2364, the judge said, it is not this court's job to save counsel from its mistakes, unquote. The point, Your Honor, is that under Brown versus Stuckey, when examining whether or not a verdict is contrary to the manifest weight of the evidence, the court has a duty to examine whether or not a $16 million outcome is consistent with the weight of the evidence presented, regardless of whether or not the defendant did a quote, good enough job, unquote, or made mistakes, unquote. And again, even if there had been a default judgment or a case had gone against a defendant in absentia, if a outrageous runaway verdict was returned, the trial judge would have an independent duty to examine that verdict and examine whether or not it was consistent with the manifest weight of the evidence, and when we look at the remittitor factors, under each remittitor standard to examine whether or not the verdict was shocking to the conscience. Here, the trial judge, in assessing this verdict, focused extensively on the fact that the defendant, according to the trial court, didn't do a good enough job, or made mistakes, or didn't object, or had a failed strategy, or didn't put on evidence. A defendant has no duty to put on evidence, and for purposes of whether or not the verdict is inconsistent with the evidence or whether it should be remitted, I would respectfully submit that the defendant's conduct or the manner in which the case was presented, or if a case was not presented at all, should not in any way factor into the equation. If we look at it under the statute, for example, under remittitor.
Well, counsel, it has to factor in, doesn't it? I mean, if you had presented evidence, then the trial judge would have had additional evidence to consider, right, in the weight of the evidence analysis. The fact that your side presented no evidence whatsoever necessarily affects that analysis. Now, maybe it's not dispositive, but it absolutely has an impact, right?
And Your Honor, I would submit that the defendant did present evidence. For example.
But you know what I mean, right? So obviously what we're saying is I understand you presented some joint exhibits and cross-examined, but you offered no experts. You offered no alternative calculation, right? So I guess all I'm saying is you said it has nothing to do with it. And it seems that it necessarily does. That your argument probably, depending on what evidence you presented, had you presented your own expert, assuming they offered some evidence that was, or an opinion that was substantially different, that necessarily would make your argument here stronger.
And Your Honor, I understand the court's point, but we are accepting the evidence as it was presented in its entirety. In other words, if we look at this record as exactly as it came in, even if the defendant had not been present in the courtroom, I believe, and I believe the law requires the trial judge to evaluate the standards under both Florida law and the remittitor statute. For example, accepting the evidence as it was presented, at the record at 1402, that was a medical record that indicated that the plaintiff had resumed all of her activities and was pain-free. The evidence taken as its entirety, and I already outlined the plaintiff's explanation of the impact this had on her life. Now, when we look at the remittitor standards, Under the statute, it says that, quote, "It shall be the responsibility of the court to review the amount of the award, to determine if it is clearly excessive or inadequate in light of the facts and circumstances which were presented to the trier of fact. And if the court finds that the amount awarded is clearly excessive or inadequate, it shall order a remediator or additor."
But it
There is-
did, but it didn't. And it did look at everything, and it didn't. So it's now here. And isn't our standard of review, arbitrary and capricious or something along those lines?
Well, technically, Your Honor, I would submit that at best for the plaintiff, it's
abuse of
abuse of discretion.
discretion? Right, okay.
But I would again submit that the trial judge respectfully did not apply the factors. The factors were identified in the order, but let's be very clear. The judge stated in her ruling that much of her decision is based on the fact that she wasn't going to save counsel or travelers.
I read the trial judge's order. What she said, actually, is basically saying you guys committed legal malpractice. You didn't put on a case, you did nothing. Now you expect me to do your job for you. I'm not saying you, I'm just saying.
I
that's the trial
understand,
judge.
Your Honor. I understand.
I mean, that's as plain as day to me. That was what the trial judge felt.
The trial judge did feel that way. And I believe, again, that when we look at the standard under the statute, which says that a verdict that is excessive shall be remitted, shall be reduced, that whether or not the defendant committed, as the court notes, legal malpractice, or whether or not the defendant wasn't even in the courtroom, it doesn't obviate the trial judge's duty to examine the factors. And by looking at the defendant's...
But don't we have to assume the trial judge examined each and every factor because it's in the order?
Your Honor, I
Maybe he
respectfully...
misapplied them, but didn't even consider them?
I would submit, again, that it is not to... I do not believe that should be assumed here. I do not. In fact, I would state to the contrary. I believe that if the judge had applied the standard appropriately, if the judge had applied, whether we look at it, again, from manifest weight or from the remitted factors, if we go through each one, the judge, unfortunately, did not apply the standards correctly.
On the remitted issue,
Yes.
I guess one thing that I'm curious about is below, you argue that the amount should be reduced, I think, to 1.5 something change, right? Is that correct? 1.5 and change?
Yes, Your Honor.
1 million and change. And then you make the same argument in your brief. So I guess the question becomes, I mean, that's a pretty low number in comparison to the actual verdict. I mean, that was an aggressive position to take. I think we might be able to agree on that at least. But regardless, what if the trial court thought, well, gee, 16 million is too high, but 1.5 is way too low, and then you argue 1.5 again here. How cabined are we by the actual amount that you argued below and on appeal?
What I would submit is that the court should reverse and remand with directions to the trial judge to make that conclusion in the first instance. And what I mean by that is we offered a number. We did. And our number was based upon reviewing 34 different verdicts that we looked at.
I guess if you could just answer my question very directly and then
Sure.
offer. But I guess what I'm asking is it all or nothing?
No, Your Honor.
Okay. Explain that to me.
Sure. And that's so this court and the trial judge were not bound by the $16 million verdict or our 1.5 approximately number that we proposed. The court is bound to examine the evidence and to determine whether or not it would have been appropriate to reduce it based upon what the judge recognized was higher than verdicts awarded to plaintiffs who've suffered far more catastrophic injuries and death cases. So the answer to your question is no. There is no nothing I see in the case law suggests that it's an all or nothing. The trial judge, but here again.
So and that's a fair point. So your argument is, look, the trial judge still had discretion to say, hey, look, 1.5 is way too low. Pick a number, but 6 is right, and do that. But on appeal, you've argued 1.5.
Your Honor,
that's a different issue. That's a different issue. It's at least argued potentially different. You've made the argument to us. We can't rewrite your arguments for you. The way I read your brief, it says the remitted should be 1.5. Are we bound by that?
No, Your Honor. I mean, there's nothing in the Florida law that I'm aware of that suggests that a court, either at the trial level or at the appellate level, is bound to accept a number proposed. We offered an alternative based upon our interpretation of what we thought.
But, counsel, we're bound by your arguments. We can't make arguments for you. We can't rewrite your arguments on appeal. So how can we then say, well, and you didn't argue that it should be remanded for just any number, any reduction?
Well, actually, I believe, Your Honor, if you look.
Oh, did you?
I believe we did in our brief. I mean, I believe we suggested that it be reversed and remanded to the 1.5, but I believe if the way we present our argument is that it can also be remanded, I believe, Your Honor, for the court to remit in the first instance, or for this court to remit it, or this court to remit it to $1.5 million. I mean, I stand by the number we proposed as I believe to be a far more appropriate reference point when compared to verdicts that are returned across the state and when compared to the damages asserted by the plaintiff.
When you're talking about the verdicts across
Yes.
the state, do the statutory factors in 768.043 require that the judge review those?
The statute itself
The
doesn't
statute
talk
itself.
about the...
It doesn't talk about that, does it?
It does not.
Okay, so that's just other courts have said, and she may consider. I think that's what
That's
the courts-
correct.
I think that might be in your brief, correct? So
That's
there-
correct.
She's not bound by those other verdicts.
Not bound by the other verdicts, but certainly bound to examine whether or not under the factors, this is a case where the verdict reflects something that is indicative of passion or prejudice, whether or not it appears that the trier of fact misapprehended the evidence, whether or not the trier of fact took into account improper elements, and whether or not the award
But
basis...
I'm talking specifically about those verdicts. There's nothing in
Sure.
the statutory language that required her to review those as part of her comparison, correct?
The statute does not.
thank you.
Florida
Counsel,
courts...
did you want to reserve time for rebuttal?
I do, Your Honor. Thank you.
Okay, you're at about 5 minutes.
Yeah.
Thank you, Your Honor.
Good morning. May it please the court. My name is Brian Lee. I represent Jessica Long in this appeal. I wanted to start by reading the court just a brief excerpt from the Florida Supreme Court in the case of J.B. versus State. It's a case that I cited in my brief, and it talks about the importance of what a contemporaneous objection does, and I think that is relevant to what we're talking about here. It says the contemporaneous objection rule serves several purposes. Most notably, the rule provides an opportunity for trial judges who are most familiar with the case and proceedings to respond to objections. Further, it prohibits counsel from attempting to gain a tactical advantage by allowing unknown errors to go undetected, and then seeking a second trial if the first decision is adverse to the client. Only when error is fundamental can the error be raised on appeal in the absence of a contemporaneous objection. And as I've set forth in my brief, fundamental error for civil cases, the case law is very clear, is exceedingly rare, meaning that courts should only in exceedingly rare cases say that something is fundamental error. And so when we look at the trial court order in the context of what the case law says about objections and about fundamental error, I believe this court's going to see that the trial court did every bit of analysis that the appellant says she did not. Yes, did she talk about the fact that the defense counsel at the trial didn't object once, didn't object substantively at all?
What about the motion after the verdict? The motion that basically said, hey, this verdict is out of whack, it's too high, it's against the manifest weight of the evidence. I mean, what if the jury verdict came back and it was $1 billion?
Sure.
Okay, now they made a proper motion to try to correct that. And in this case, I would presume if the trial judge upheld $1 billion verdict, we would probably overturn it. I'm just thinking, I'm speaking out loud, not for my colleagues, but under the facts of this case. And that would have been a preserved argument, and that we would be entitled to provide relief. But that's not this case, right? So we have one in which it's really the non-economic, the 11 million, in my view at least, the 11 million because that's 11 out of 16 million. 11 million of the 16 million verdict is future non-economic damages. So isn't that where the action really is that's the amount that they're really targeting?
Well, I believe what their argument, Judge, and just I could be wrong about this, but they are the only part of the jury verdict that they are not contesting is the past medical expenses that the jury awarded. They are wanting this court, and they want the trial court, to remit the future medical expenses. That's their argument, Dr. Sherbin.
Counsel, I think you're right. They're challenging almost everything, but I think Judge Makar was more trying to laser in on perhaps the biggest part of the case, and that is the non-economic damages.
Okay,
right?
sure.
And I think the point he was making was simply this, that at some point, the fact that they didn't present anything in their case doesn't win the day for you. That is not dispositive. That's not the law. There's still a manifest weight of the evidence standard. And if the verdict here was $1 billion, can you agree with us, with me, and apparently Judge Makar, that would be reversible because it would be against the manifest weight of the evidence? $1 billion verdict.
$1 billion verdict, yeah, I could agree with that.
So
Concessions are okay. Concessions are okay.
Well, yeah, when we're asking about $1 billion verdict, it's so the point is this: the fact that they didn't put on any case at all is, I mean, it's difficult to understand for sure, but that doesn't win the case for you, right? The trial judge still had to look at the evidence that was presented. And again, a lot of it came in without objection. A lot of it was objectionable, but they didn't object, so it came in, right? The trial judge still has to look at all that evidence and decide, is the verdict, the $11 million for non-economic damages based on this evidence, is that against the manifest weight, correct?
I agree.
Okay.
And she did. When you look at her order, I
think part of the problem is she focused heavily on the fact that they didn't offer any case, right? I mean, there was quite a bit of discussion on that point.
There was, but I think that, as the court has already noted, when you talk about things like manifest weight of the evidence, and really actually remitted her also, there is no way to divorce entirely the fact that there was no counter evidence entered. Because when you're talking about manifest weight of the evidence, a court is looking at a balancing, like a weighing, and saying, you know, on this side I have this, on this side I have this. Is there something that tells me that the manifest weight of the evidence should have led to a different result?
Well, I think we already established, though, that it's not always this versus that. It could just be there's one side of the story here, but there's no way it's worth $1 billion.
No, I agree with that, Your Honor, but that's not what the trial court did. That's what the defendant wants to. That's what Travelers wants this court to believe. That's not what the trial court did. Did the trial court put in the order things like no objections and things? Absolutely. It's in that order. But I would also say the motion for remitted, the order, portion of the order that talks about that motion is from record site 2393 to 2401. It's 8 pages. The trial court does not just talk about the lack of evidence. She does. But she also goes through every single factor that is within the remitted statute. She talks about the comparable verdicts. She talks about how she does not believe that those are comparable because of the stance of this case and because of what the evidence was. And so when she goes through all these particular points in the remitted statute, regardless of what she says otherwise, she has done what Florida law says she's supposed to do.
What about the part where she says that she's guided by? I think and I'm not going to, this is not an exact quote, but for sure the words guided by, and the fact that there was no evidence presented on one side. I mean, that kind of contributes to, I think, opposing counsel's argument here. So how would you explain that?
Sure. She does say that. She says, I think it's at page 2401, she says, the court is guided in large part, right? She says that, but immediately after that, she goes through, again, this is in her conclusion section. This is after she's done all the analysis. And Judge Deering's going through a conclusion. She talks about everything that I've talked about, and then at the end of it, she says, nevertheless, goes through all the, you didn't do the evidence. It says, nevertheless, the court recognizes that if it found this verdict shocking to the judicial conscience, it would be required to grant a remediator, even if the amount proposed by the defendant was not based on the actual evidence presented at trial. She recognized that even without everything else, she would be required to do that. At the end of the day, she did not do that based upon her analysis she made. And so when we look at this particular order, the abuse of discretion standard is twofold, especially when you're talking about a remediator. You have an abuse of discretion based upon what the jury did, meaning the jury's verdict is given weight by this court. But it's also buttressed, and the case law that I've cited to talks about it's strengthened by the fact that the trial court then looked at it, was there at the trial, was the judge that was there in person to hear the evidence, and decided that a remediator was not warranted. And so I heard Judge Makar, I think, talking about the arbitrary and capricious standard. I've seen that before. It's kind of a heightened standard. It's more than an abuse of discretion standard that this court would need to say happened, because Judge Deering's order strengthened the jury verdict itself. And it's not that it didn't have evidence. One of the things that that Travelers doesn't really deal with within its briefing is that this was not a situation where the person was older, was a 80-year-old person, only had maybe a 3-year statistical life expectancy. This was Jessica Long was, and I may get this wrong, hopefully I don't.
She had 53
But she was
years.
26 at the time of the crash.
Her life expectancy was 53
The life
years.
expectancy was 53 years. And the only evidence that the jury was given was that she was in pain, she had been in pain since the crash, and not only that she would continue in pain, continue with mental anguish, all of the different elements that Jessica Long proved to the jury, but that those would get worse in the future. Plus, adding on to that, she would need all this future medical care.
Can we go back to the future non-economic damages? Didn't even legal counsel, Ms. Long's legal counsel, I think he asked for about $7.5 million, and they came back at about 11.3. Is that a reason to reduce? He asked for $10 an hour, and they gave a lot more than that. Is that not a reason to reduce the verdict?
No, it's not, because of the fact, and this is just straight from the case law, that what counsel's arguments are to the jury about the method that they should use to award their damages is only that. It's what counsel wants them to do. The jury has the ability to accept it, reject it, or do something else. And the case law very clearly says that, especially because we're kind of honing in on non-economic, especially with that type of damages, we are asking the jury to measure what the case law says is typically immeasurable. And so there's a huge amount of deference that is given to the jury to determine that. And there is no formula for doing that.
What I hear you saying, I think I'll put it this way. When I read the facts and the evidence and then saw and the verdict, I'll be honest with you, I was pretty surprised at the number. It seemed quite high. Your point is that that's not the standard on appeal.
It's not.
Yeah.
And
if the trial judge had granted a new trial or remediator and said, hey, this is too high, I assume that based on that same very deferential standard of review on appeal, you would say probably that would also be an affirmance.
Well, and Travelers would be coming up and giving you the same case as I am, that says that trial court's decision has a lot of weight for this court. And I wanted to touch on something I think that you said, or that I was going to talk about. The case law is very clear, and this is undisputed, I think, that there's this concept between sort of raising a judicial eyebrow that you see in the cases.
Well, that's what didn't the trial judge use that phrase?
The trial court even used that phrase and said, and the trial court frankly said, look, is this something that I might have given a jury? Maybe not, but that's not the standard, and she recognized that. She recognized that she had to divorce herself as the trial judge from what the statute says, from what the law says. And so she found that this verdict did not shock the judicial conscience. And I could just give you the numbers, Your Honor. The numbers are $4.5 million for future medical care, $131,000 for past medical, $451,000 for past non-economic damages, and $7.5 million for future non-economic damages. So we're sort of maybe talking about a 3-to-1 ratio for the past, and maybe not even a 2-to-1, less than a 2-to-1, meaning that it's double, it's less than double what it is. Now, does
Counsel, you asked for 7.5 on the future non-economic, right? But the jury awarded 11.3, isn't that right? At least that's what it says here. Maybe.
Right, yeah, right. So, I mean, we're talking about...
So my question is, you asked for $10 an hour for the
Right.
next 53 years. The jury awarded another number. I don't have a calculator, but by hand, it looks like it's around $14 or $15 an hour, based upon my calculation. So the jury came up with that number. What was the evidence at trial? You said 10. Did that come from an expert? And then was it cross-examined? Did they say, no, it should be $5 an hour? If you could just fill me in on that. I don't recall.
Sure, no. The evidence was from Mrs. Long, from Jessica Long, about the hours, right, per day, for each of the categories of non-economic damages. The numbers themselves, meaning that how much is an hour, was based upon sort of a per diem hourly rate that Mr. Block put in front of the jury as a suggested way to determine these damages. That's something that's done very really throughout Florida, and the reason it is because of the fact that the Florida law says there is no set formula for the jury to use that. And so what counsel do is they put their own formula. They say, sometimes they say you should this much per year.
There's no set hourly rate either by law or in the jury instructions.
There is not. There is not, and that's why it is a suggestion to the jury. And frankly, that's why the jury
When
could
we say hourly,
not do it.
we're talking about the testimony at trial of the number of hours per day that she was in pain, right, and that sort of thing, right?
Correct. Yes. And so there was
Counsel, we don't even really know what the formula the jury used, do we? I mean, the jury could have just entirely rejected your $10 an hour thing and could have rejected an hourly sort of number and just and come up with some other way to calculate this non-economic damage number, right?
Very true. And the trial court, I think, even noted in her order that it was unknown to her, or frankly to the parties, exactly what the jury did. And that is the point. When the trial court is looking at a remittitor motion, that's why those factors are in there.
Was the argument that it was 24 hours a day for the next 53 years?
No, I believe that there was arguments as to each element of the damages. Each of the non-economic damages, the case law says can be awarded basically on their own. So the amount of pain and suffering, the amount of inconvenience, loss of enjoyment of life, and et cetera, et cetera. So there was evidence given to the jury about each of those elements, and Mr. Block said you could assign this number to those elements.
24 hours a day, or was it 16 hours when she's awake?
I don't know exactly. I'd have to look at it, Judge, but
I'm just trying to figure out what the jury had before it and what I'm also, in the time you have left, wanted to hear about the cross-examination. In other words, what number did they put forward? Did they give an hourly number?
They didn't give anything. Defense counsel did not, from what I recall from the record, and I'm sure counsel will tell me if it's otherwise, basically just said, do whatever you think is right. There was no formula that was given to the jury by defense counsel, no analysis of that. Frankly, Your Honor, there was no evidence to rebut what Mrs. Long said was all these hours. So I guess I want to, just in my time remaining, I want to sort of paint the picture here. The jury was given all of this evidence. The jury was given undisputed evidence from Ms. Long about how she suffered and how she still suffered. The jury was given undisputed evidence as to the amount of years that she would have these permanent injuries and would suffer these non-economic damages. And then in closing argument, the jury was given a formula. Mr. Block said, this is the formula that I would suggest to you. You can use what you want. And the jury did not have to follow it. The jury could have done their own formula. We don't know. But that is not the point, because of the fact that when the judge looked at all of these factors, when the judge looked at the evidence that the jury had, she said, look, I'm not going to look at this evidence like all the stuff you said shouldn't have come in didn't come in. Because that's part of Traveler's argument, is that, well, you should look at all this evidence that came in and sort of take that out and say, well, it shouldn't have came in, so that means the manifest weight of the evidence was not against us. That is not the correct way to look at it, because the evidence was there.
Look, can I ask you one before your time is out? On the
Yes.
future medical expenses, Dr. Sherbin, I think he testified that Ms. Long may need a couple of more neck surgeries if the first one went bad. Is that a reason at that point? Is that an abuse of discretion to not reduce the award at that point? Is that allowable?
It is allowed, Your Honor. I set forth all the cases that talk about even things like possible are okay
There's no
for
other
that.
testimony or no witnesses to rebut what he said, correct?
Correct. And also, if you look through his
He
testimony,
accepted you had a joint exhibit with all those expenses, which they jointly entered into evidence, correct?
that's right. And then during his testimony, he was asked multiple times by Mr. Block as to every single category and cost, do you have this opinion within a reasonable degree of medical certainty? So it's not even that he said possible, probable, no opinion about reasonable certainty. He was asked very specifically at trial on every single one of them, and he said yes to every single one of them. And so the evidence is very clear that this would have came in based upon the testimony. If there was an objection, what would have happened? We don't know. But
Before you sit down, Long made a offer of settlement, I think it was, for $100,000. Was that it?
I'm sorry, what, Your Honor?
Wasn't there an offer of settlement?
The policy limits, the UN policy limits, did they make was there an offer of settlement?
Demand for judgment, I guess.
At the policy limits?
I don't
Okay,
know,
that's
Judge.
fine. I'm
I
sorry,
would
I
assume,
didn't.
but I don't know, Judge, because
Okay,
that
that's
wasn't
fine.
part of
That's fine.
obviously
That's
what
fine.
it
We'll
was.
figure it out. We'll figure it out.
So, Your Honor, for all the reasons that I've set forth, as well as my brief, this court should affirm.
Thank you, counsel.
Your Honors, one quick point. On page 2 of the reply brief, we do specifically note that the case could be remanded for a minute or two an appropriate sum. So I wanted to just answer Your Honor's question about our position. Our position does remain that we put in what we believe to be a more appropriate number, but we also included in our brief an argument that it could be remanded to be remitted to an appropriate sum.
I mean, counsel, for future
Yes.
reference, usually you can't make a new argument in a reply brief. I'm not sure of any example where you can actually, but
Your Honor,
usually
again-
those arguments need to be made in the initial brief.
Your Honor, again, and respectfully, it was not a new argument. It was just a
I'll
framing.
go back and look
It was
through
just
the-
a framing of the argument.
Just so you know, I'll go back and reread that section just to make sure I hadn't misread it.
Thank you,
Counsel,
Your Honor.
one thing I was thinking about is you focus a lot in your brief on the fact that Ms. Long went back to various activities, and you sort of point to that well, she went, I guess it was walks on the beach and Universal and theme park and various things, and you sort of say, hey, look, this is a reason why this verdict is out of line, it's too much. But I mean, I guess we don't really know how the jury evaluated it. Couldn't the fact that she was so active before the car accident actually hurt your case in front of the jury, that she wasn't just sitting around watching TV, she was doing all these active things, and now she testified very clearly she can't do them like she used to be able to. She doesn't do them as much, and she can't do them as, when she does go then do them, she has to rest, and it's shorter periods, and she can't enjoy what she used to do as much. doesn't that potentially hurt you?
Your Honor, no, it does not. The problem here, Your Honor, is not when the question for the trial judge when examining the remitter factors is specifically, does the award bear a reasonable relationship to the damages proved and injuries suffered, and whether it is supported by evidence in a logical manner. The fact is, okay, and this goes back to respectfully the reason why we do examine comparative verdicts is because when you have a circumstance where you have a $16 million award and $11 million of that for future pain and suffering, and you have an individual who described the activities she continues to do, where she testified that there's no activity she did before that she no longer is able to do, but it is now different, was her testimony. The bottom line is that if a person continues to enjoy a certain quality of life, when one compares that to the catastrophic nature of injuries suffered where awards are far less, as the trial judge recognized and stated over and over again, then that under the statute requires a reduction. The court, and I believe, I understand that the court referenced, the trial judge referenced the factors, the remitted factors. But the point is that the court in her order said, conclusion at 2374, quote, as this order makes clear, the court is guided in large part by the fact that little defense was presented, unquote. And I respectfully submit that that has nothing to do with the statutory factors that require a verdict to be remitted. And I will say, Judge, respectfully, it makes no difference if we suggested it be remitted to $1.5 million or $1. It has no bearing on the judge's independent duty to reduce a verdict that is excessive. And this court, if the court believes that $11 million is excessive, which was mathematically 150% of what plaintiff's counsel requests in closing, then I submit that this court also has a duty to remand for the trial judge to remit in the first instance. I believe that the law requires the court to do that. The statute is clear on the remitted factors. If the court concludes that the verdict is not supported by the evidence, regardless of what the defendant did, regardless of whether the defendant put in experts, regardless of whether the defendant objected, even if the defendant wasn't even in the courtroom, Your Honors referenced a $1 billion verdict. What would be too much? And the bottom line is that if a verdict is excessive compared not to what the defendant did, but what the injuries were that were represented to have been suffered, the court shall reduce the verdict, shall. And I believe, respectfully, that that applies to the trial judge and to this court. If this court looks at this $11 million future pain and suffering award, and it says that this verdict, compared to the amount of damages referenced by the plaintiff, is excessive, then it has a duty to remit. So I would ask that this court reverse and remand either with instructions to the trial judge to grant a new trial or to enter an appropriate remitted sum. Thank you, Your Honor.
Thank you, counsel. I think we'll go straight through. Understand? Is that okay? Do you want to just go straight through to the next case?